Good morning, everyone. Today we're looking to have a webinar on ESG leadership, navigating risks and opportunities for business leaders and legal counsel. My name is David Kerr and I'm the practice group leader here in LegalVision's corporate team. Just a couple of housekeeping items before we get started with the webinar. You do receive a copy of the recording and the slides at the end of the webinar. You'll have an opportunity to submit your questions in the live Q&A, and we'll get to those answers at the end. And once we do get to the end, you'll have an opportunity to fill out a survey, and we ask that you please do, because that survey is the way that you get access to our free consultation. That free consultation gives you an opportunity to ask questions about things you have heard today. Before we do get started, a poll question would have just popped up on your screen, and we like to get an understanding of who's in the audience today. So if you can just fill that out, we want to know what brings you here today. Is it you just want to understand what key ESG principles are? Are you looking to get a bit more of an understanding of the Corporations Act and how it's enforced? Are you interested in the new sustainability reporting requirements, or are you more looking at the process and implementation side? Otherwise, if you're just here to learn, then that's also a very valid reason. So while you're answering those poll questions, I just wanted to walk through what we're going to talk about today. So we will look at, what are we looking to get out of it? We will discuss the key ESG principles, what it involves, what ESG is all about. We'll look at the legislation and some of the recent updates, how the government is enforcing ESG. We'll look at governance processes, so what you can do internally to make sure you are having effective control from an ESG process perspective. And we will then put together some key takeaways for you, which you have in the slides and can take you out of that. So the results of the poll are popping up. It's quite a mixed bunch here, almost evenly spread. We have a slight majority for those of you who are interested in learning more about the legal enforcement and the Corporations Act and how it looks at that. So I will make sure we give very clear directions on that and spend a bit of time discussing that element of the presentation. So what are we really getting out of today? Getting an understanding of ESG, what it covers. It is a pretty broad requirement. It is both legally and legislatively enforced. It is also enforced by the market. We'll understand how that regulatory environment came about and ways where there can be other places that it's indirectly enforced. And then we'll talk more about your internal policies and process and what are some of the checks and balances you need to put in place so you don't fall foul of enforcement. So getting started with what ESG is. It's really important to understand that ESG has a broad meaning. There's no singular defined concept. Most people see ESG to include modern slavery, environmental policies, all of your sustainability, which now falls under the sustainability reporting requirements. Interestingly enough, climate change has now become well accepted that it's a very separate issue to sustainability generally. It is really important about governance, so what companies are doing, what organizations are doing to enforce or to change behaviors in the ESG space. And then greenwashing. Greenwashing is the subsection of enforcement that really has been a target most recently from the government agencies, and that's where companies are making statements that are holding out as if they're following ESG principles, but may or may not be well backed. So if we're thinking about ESG from a legal framework perspective and the environment you're operating in, it's really important to understand that ESG is something that is not just mandated by legislation or government policy. It's something that's come about through the expectations of society and the ecosystem as a whole. So for entities which take on investment, whether you're a privately held company taking on investment from an individual or a VC or private equity, up into listed companies have the added challenge of sort of activist shareholders who sort of join groups and take equity stakes in companies to help drive change. There is regulation, market pressure from your customers or from your suppliers who have these policies or have these policies mandated on them, and they push it downstream, and also your employee value proposition. So the three key elements of ESG, the environment, social and governance, are quite clear in sort of how that framework is set out. Some of the environmental things you look at is energy consumption. So sort of some of your leases will have requirements for the buildings that make you report on energy consumption. You'll have your own targets in sustainability reporting. Waste management, if you are in a property, most requirements now have that. If you're a company that has ISO certification, you'll have strong requirements for your own self-governance and reporting and benchmarking for environmental protections. On the social aspect, we'll look in this presentation a lot about the supply chain, so modern slavery particularly, though if we think about employee value propositions, it is sort of a whole webinar in and of itself. So diversity, equity, and inclusion programs, your sort of more HR focused ones. We won't talk heavily about it in this webinar, but it is something that falls into it. And then governance, looking at both legislatively enforced governance and your internal sort of processes and the way you can make sure that you are doing it in a legally binding manner. So what does the legislation say, and what are some of the most recent updates? So the legislation has in sections 180 and 181 of the Corporations Act what are colloquially known as the directors' duties. Probably a little bit misleading because they don't only apply to directors of company, but they do apply across directors and officers. And many of you as business leaders and in-house counsel will be captured under that officer's definition. Anyone who has the ability to influence a company, specifically around the financial outcome of the company, will be captured by the officer's definition. Now, officers do have the same obligations as directors in respect of this section, though most of the enforcement proceedings have usually been targeted at directors, though the defence to these to these provisions are always about whether you're using reasonable business judgment. So are you making informed decisions, or are you just signing off on items, especially if we're looking at greenwashing or policies and procedures? Are you following a substantive basis to form your decisions or not? Now, other areas is the obligation for directors and officers to act in the best interests of the company. And that means that you can't just say, well, making a profit is in the best interest of the company. So long as the company is getting a win, I've acted in the best interest of the company. The legislation says that's not enough. You merely have to take into account all of the items about the reputation of the business and the enforceability of legislation over companies. So penalties, the major consequence from breaching these requirements are penalties. Penalties can be quite substantial. So the penalties are up to over $1 million, or if there is an outcome that can be quantified, then it can be based on the total damage caused or benefit received. So greenwashing itself is something that's come about really out of a combination of both the ACCC and ASIC. So greenwashing is focused on the principles of deceptive and misleading conduct. So both the ASIC Act, Corporations Act, and the Competition and Consumer Act and Australian consumer laws have provisions about deceptive and misleading conduct. And those provisions have really focused on not the intentions of parties to mislead or deceive, but whether the recipient of those statements or claims have been misled or deceived, or it has a likely impact of misleading and deceiving those recipients. So ASIC looks at enforcement from a financial services point of view, whereas the ACCC is looking at enforcement from a consumer point of view, so for your products and services. What the guidance tells us in this space, and what the cases to date have told us in this space, is what is the accuracy of the statement being made? How did you form that view? So if you're making statements about something being scientifically backed, if you're making statements about how the market has perceived your product or service, then it's a matter of looking behind to the investigations you've done and what you've relied on. So an example of scientifically backed, one study that you have funded, for example, may not be considered by the ACCC or ASIC to be scientifically backed if you're making it sound like it's a way where it's universally accepted. One of the more recent cases, or probably the landmark case in this space, and it's a financial services one, is what's called ASIC and Vanguard. So Vanguard is a investment product provider. And a couple of years ago, Vanguard launched a product where it held out to the consumers that they were providing an ethically conscious investment opportunity. And the opportunity was for you or the consumer to invest in a product which had some claims about the ESG criteria that it was putting forward in the space. Now, the particulars of this matter is it was, as a financial product, there's an obligation under law to have a product disclosure statement. So there were statements in that product disclosure statements about the processes that Vanguard undertook from an ESG principles point of view. There was also a YouTube interview that one of the members of Vanguard had done, and there was also an article on a financial website where somebody from Vanguard was interviewed. Now, interestingly, ASIC went to the efforts of looking at those things. So it wasn't just the product disclosure statement, which is mandatory for the product, but they looked at it and they really analysed a couple of things. But one of the most important one was the product disclosure statement and the claim that it excluded certain types of investments. So the ETF product was an opportunity to invest in this fund, and this fund will hold shares in a bunch of entities, but they said the entities won't include the military, the fossil fuels, tobacco, things like that. So that statement was put out to the market and investors jumped on board and thought it was a great product. Now, this actually came about by some self-reporting in the first instance by Vanguard. They realised their processes weren't done correctly. They self-reported, and then ASIC investigated further and decided to take it through to prosecution. And when they started analysing the processes and procedures that Vanguard had undertaken, they found out that almost half of securities weren't screened at all. Vanguard said, well, we did do more than half, so it was screened. ASIC didn't take that view, 46% weren't. But, more telling was, if we're talking about the total value of the equities held in that fund, well, 74% of the total value weren't screened. So what did ASIC say? ASIC said, well, despite what happened, it is quite clear that your statements weren't backed by procedures and process. You have misled the market because it is quite clear that it isn't vetted and those things aren't excluded. So they sought enforcement in penalties by way of court order, and they were successful in that case. What's really interesting about the enforcement of greenwashing is that it's not necessarily based on harm done. So in this case, there was mention that the fund actually performed quite well and investors, had a return from their investment. So it wasn't the fact that they had misled investors to invest in a fund that failed. It was a well-performing fund by any means, but as I said, it's the case that we don't want to have organisations greenwashing, misleading the market by providing products that are not true to their cause. So ASIC sought penalties, over 21 million, and was successful in getting almost $13 million worth of penalties. And this is for a single product. So it is quite a significant fine. And it is something that sort of has changed the landscape in terms of how much enforceability will happen. Now, deceptive and misleading conduct or greenwashing is a case that's gone through to prosecution and an area, a high target area. Both ASIC and the ACCC have announced extra funding in this space for a task force. They've both put on their websites that this is a key area of focus for them. But it's not the limitation of legislation, and specifically not in the Corporations Act. So one of the latest requirements or changes to the Corporations Act, which at this stage will only affect the larger entities, is there's changes to 292A of the Corporations Act, which any reporting entity who has to provide financial reports now has an obligation to also provide a separate climate statement and a separate statement about sustainability. Now, the requirements in the climate statement at this stage in the legislation are quite narrow. It's not clear exactly how those reporting will be required or tested. We're in a new area of law, but there is a requirement that anything is a material financial risk, which is as a result of climate, or a material opportunity that can be taken by the company, then that has to be now disclosed and provided in the reports that go with your financial reporting, something that you'll work with your auditors on if you're falling in this. But that is now a separate part of the report, a specifically legislated one. Now, this is being rolled out over a 3-year period. So right now, or as of 1st July, the criteria is for the larger entities. So you have to have either $1 billion, or you need to have satisfied 2 of the criteria, so $1 billion in assets or 500 million turnover, or more than 500 employees. But over the next 2 years, that will slowly increase in scope, and it will roll down to the point where all disclosing entities who are large proprietary companies will then have to disclose. So by 1st July 2027, it will capture the smaller end of the large corporations. Another area of governance or legislative enforcement is modern slavery. So any entity which has more than $100 million in revenue is now a reporting entity, or has been for some time, a reporting entity that has to provide a modern slavery statement. Now, the interesting enforcement pathway that the government has taken for modern slavery is a bit of a name and shame approach. So if you're captured by the reporting requirements and you haven't made your modern slavery statement, or haven't published your modern slavery statement, then you can be added to a list of wrongdoers. And then that is the way the government currently is enforcing it. Now, there has been a review into the Modern Slavery Act and some recommendations to be made, and some of the recommendations are around enforcement. And we may see changes in this space, but currently the only real enforcement is the name and shame. But that can have significant impacts for organisations, as upstream suppliers, a lot of large organisations will do due diligence on their customers around their modern slavery processes. And if you're one of the people named and shamed on that publicly available resource, then suppliers may not supply to you, or customers may not acquire from you. So it still can have market impacts for your business, even if there's no monetary penalties at this stage. The impacts of the modern slavery statement can still flow onto the business. So it is a risk for business, and it's a risk by way of what the market will do if you are in breach. Now, we are talking mostly to you as business leaders and legal counsel in organisations. So a big part of ESG is governance and implementation. So whilst there is a reporting requirement, we talked about what you can and can't say in terms of this misleading and deceptive conduct, whether you're a financial services provider like Vanguard or it's a product or service. The ACCC will take a similar view. If you're holding out a product to be something that it's not, then they can also enforce. On the other side of that is what processes and systems are you putting in place internally that are ESG related, and how can you stand behind them? And if that's how the board is signing off on statements because a process or procedure has been followed, how do we know if we're following good governance and implementation? So if we talk about policy design, it's really important to be involved in that process from a leadership or legal counsel point of view to really get an understanding of what's the statutory and legal framework you have to work within. So if we're talking about modern slavery, you have to work within the requirements of the Act. If we're talking about diversity and inclusion programs, you would have to work in accordance with Fair Work and anti-discrimination legislation. But beyond that, once you've understanding the regulatory environment, you have to get an understanding of what is your organisation trying to achieve by implementing such a policy. So many organisations who want to do this is either because their customers are telling them that's what they care about, investors are driving it, the employees within the business want the company to take views on certain things, and that drives change or that drives policy within the organisation that leaders are trying to implement. So getting an understanding of the regulatory framework and the goals really helps us get involved in that early stage of design to make sure what we're trying to put down on paper can actually be achieved and implemented. So it's really important that if we are designing policy, if it has a lot of references to legislation, it has terms that unless you're a lawyer you won't quite understand, or you're making assumptions of people's knowledge of the law. When it comes to actually applying that policy or procedure throughout the organisation, the frontline workers may not understand it and it won't be applied the way that you might think. So when it comes to implementation, it's really the success of implementation we see is on the design stage, and if you've made it easy to actually apply. So one of the things about implementation is some people take policy of the view, you put out a policy, you have it on your website, and you circulate it to the staff, and then that's it. You've done. You've ticked the box. The policy is implemented. Yes, we have a policy on this. But realistically, if it's something you're going to rely on or something you're going to say isn't just mere statement out to the people, misleading into thinking we're a sustainable company, or we care about climate change, or we value our employees, it really is going to be based on have you verified and tested your own policy framework along the way. So I mentioned earlier ISO certification, so the International Standard of Certification. And if anyone has that in their business or has a requirement of that, the main standards that you usually see are work health and safety, quality and environment. They're the three most prevalent ones. Security and privacy and other ones like that, sometimes required for your insurances. But those three main ones are quite common, and ESG will fall into your environmental ones, your work health and safety, maybe. One of the key principles, and ISO is sort of the gold standard in policy implementation and design, one of the key principles around that is testing of your own policies and the effectiveness. And the other one is continuous improvement. So what are you doing each year to refine your policy, to check if it achieved your goals, to check have records being kept to show that we are doing this? We're talking about modern slavery. How often are you approving service providers or suppliers? Are you checking their policies? Are you taking any steps from a due diligence point of view to see foreign suppliers in their jurisdictions? Are they using labour that's not approved, or processes, unsustainable processes, and things like that? So if you're developing this at a business leadership point of view and you're expecting the frontline people onboarding new customers and suppliers to be able to apply it, well, how have you made it? How have you articulated it in a way they can understand and actually apply? And then what sort of quality documents are you keeping on a daily basis? Is it 1 in 10 things you're you're sampling? Is it all of them? What's the process? Do you have financial limits where you can bring on suppliers up to a certain amount, which don't need the vetting, but over a certain amount you do? So it's important that you have those processes, and then once it's implemented, having a regular maintenance and governance process. So why is this really important? Usually process, policy implementation and design will result in a document that is presented to a board member. Now, if we go back to the director's duties, business judgment is your ability to rely on the business judgment defence is going to be focused on, was the director providing a standard, or was the officer providing a standard of due diligence required? So a policy has been presented to the board. Here's the final policy. Can you please sign off? And the board just says yes, signs off. And then statements are made relying on that, which are misleading. It may not be enough of a defence to say, yes, reasonable due diligence was taken. The board, or if you're sitting on the board or advising the board, really they should be asking questions about how the policy was formed, what external consultants were engaged to provide specific advice, if that advice isn't able to be obtained within the organisation. The other things to look at is, what if you're making any reliance on best practices? Are we talking about an industry accepted best practice guidance published by an organisation? So, for example, when you work health and safety one, Safe Work Australia often has codes of practice. But if it's something else, it's about a product, a unique product, how it's being used and its environmental impacts. Are we talking about a one-off case study? Are we talking about widely accepted peer-reviewed journal articles? Are we talking about research we've funded ourselves? And then how clear is our statements on that? If we have a policy about research and development and the things that we will go through to test our products before we make claims, have we made sure it steps out that criteria that you need multiple sources of verification, or what other processes are involved in that policy, so that when it gets to the board and they ask those questions, you say that's already dealt with in the policy. We have the procedural document that says the policy has been followed for this product, and the board can be satisfied in signing off on it that the statements that they're about to make in reliance on the organisation following its policies and procedures have been followed. And if they're not, that's an opportunity for the board to raise questions on, well, should further expert evidence be gained or sought to be able to verify the statement? If not, you have something very novel, then it's about making it clear. In our test to date, this is the findings of our product and its environmental impact, rather than saying the scientific community supports our product. So it is really important at a board level, when we're talking about signing off on policy and procedure, that we do have good process, that we're giving enough information to the board, or if we are the board signing off on this, we are asking enough questions. Your minutes will usually say, this was tabled, these were the questions had, and after satisfying their position, the board has signed off on this based on that information being presented. So it is really great governance to do that. So whilst we are focusing on implementation and legislation, we're talking about individual personal obligations here, which, as we saw in some of the first slides, can have multi-million-dollar fines attached to them if things go wrong. So what do we really want to take away from ESG? ESG is really about our stakeholders. So whether that's our suppliers, our customers, our investors, our staff, everything that is governed in the ESG space, especially those which aren't regulated by government, those that are regulated by the market, is all about the stakeholder. So we need to be consulting with those people. We need to be seeing what is actually wanted to be achieved in our goal setting, so that our policy is being implemented in a way that achieves those things. The legislation in this area is updating. It's probably a more recent area of focus. It's not necessarily brand new laws outside of the sustainability reporting ones, but it's the way that the government has taken old concepts, or concepts that have been around for a long period of time, like deceptive and misleading conduct, and now really focusing on the ESG application of that rather than other applications. And then the last one is really just about all the things I said to date, which is where often business leaders or lawyers, in-house counsel advising on the wording, the way to say things, what does the legislation say? Sometimes it's not just about what is being said, and no amount of wording can save us from deceptive and misleading conduct or save us from not following legislation. There is times where we have to consult with experts to make sure that the substance behind what we're relying on to make those statements is actually valid. So there is a requirement in many cases to use expert evidence. Before we move on to answering some of the questions that are flowing through, I just wanted to give you an opportunity to access the QR code on screen and download our General Counsel Toolkit. LegalVision offers some great tips in that guide, looking at streamlining your operations, reducing costs, driving efficiencies. That guide will be for you. We have some other upcoming webinars at the end of July. We have some great presentations being done on updates to the recent employment law changes. Just quickly, LegalVision offers a desk extension service. So we, unlike other law firms, we offer a all-inclusive end-to-end legal service package, which is based on a monthly fee. A lot of in-house counsels, clients of ours that have it, it really helps them extend their capabilities and their capacities. We can help streamline and drive efficiencies through process and playbook generation. It's really cost efficient because we're spending time getting some of the everyday admin tasks that you don't have the time or resources to automate and make efficient. We work with organizations on that, and we can deal with multiple stakeholders through our tech-driven platform. So some of the questions that are flowing through, and there is a few of them, so I may not get to them all. First question up is, what is the current ESG specific legislation here in Australia, and what do you anticipate will be introduced in the next 5 years? So some of that is probably being answered through the webinar so far. So the ESG specific legislation, changes to the Corporations Act around the reporting. Modern slavery is something that's been around for a while. It's very hard to anticipate what will be introduced merely because we have an environment where it's unpredictable. So if we look across the United States, where diversity and equity inclusion programs are being banned or discouraged, they're being taken away, and we still have organisations in Australia that are saying, no, we're not following that trend, we're going to implement them. We have a Labor government which traditionally has a focus on the Fair Work Act and employee-related laws, so we may see further changes in DEI type laws being implemented here. It wasn't that long ago the right to disconnect and other laws were brought into place. So, over the next 5 years, we can still see further legislative change in that. And I think there will be further legislative change around the sustainability reporting and climate reporting once that has gone through a few years of reporting and the government has collected data on what's being done and what isn't being done and whether it's actually achieving the government's policy directives behind that. So they're probably two of the spaces that I think we will see change, but it is very hard to predict given that other countries around the world are taking different approaches. Does this apply to privately held businesses? Yes. So some of the legislation does apply to privately held businesses. So a lot of people see ESG as something that only those on the ASX and ASX top 50 are forced to do through the listing rules or market pressure. If you are a privately held company that hits the turnover requirements, then you're still captured by the legislative changes. It is not just for public companies. There's a very specific question about board governance here around directors' IDs. Directors' IDs are mandatory. It rolled out some time ago. So directors' IDs, anyone who's a director of a company before they sit on the board must have applied for that director's ID. That includes people who are foreign directors. Cross-cultural, so good governance in cross-cultural companies where expectations and standards differ across jurisdictions. So this is a really great question, and probably one of the challenges that global organizations have. And as I was discussing about the changes from country to country, that's where it makes it a little bit more complex, especially from an implementation point of view. So if your organization is going to take a global approach to ESG, it may limit the scope of discretionary ESG elements because some jurisdictions will allow it and some will have regulations in that space. A lot of people like to comment that Australia is one of the most regulated jurisdictions. Some of the specific examples here talk about Asian jurisdictions and New Zealand. Don't know much about laws in Asia to comment on that particular nature, but New Zealand has a very similar framework to Australia, and the laws often quite closely reflect each other, though there is differences. So if you are a true multinational organisation, global ESG principles and policies can be difficult to enforce, and it often requires even more thought about bringing together experts because you will need experts relevant to each of the jurisdictions. Really good question here is how to assist company directors in their duties under the Corporations Act. So those of us who are advising directors, as opposed to those of you in the crowd today who are directors themselves, the directors' duties provisions of the Corporations Act seem pretty straightforward in their language on paper, but how do you actually do enough due diligence? How do you get satisfied that I'm making a business call here that is in the best interest of shareholders as a whole? They're some of the questions that we're called on to advise on all the time. But realistically, the fundamental principle to take away from that is, if you were to think about who is this decision going to affect, what are some of the things that they would want to know in the basis of forming that decision? What would a reasonable person expect you to do in coming to a conclusion on that? So the best thing you can always do is to at least have shown that you've taken steps to interrogate the process and make sure the process is sound, rather than just get a pile of documents presented at a board meeting and they just get signed off one by one without any questions asked and say, well, I expect management is doing their job and going forward. If you're working in a company secretarial sort of a process, or legal counsel and you're advising boards, putting together board packs with information, with enough information in those packs to say, these are the underlying documents that relied on, here's the summary of the process undertaken and why these are important and who was involved, to at least show that the directors then have enough information to either have in their own time prepared for the meeting, come to the meeting well informed, or to be able to come to the meeting and table questions and can have those questions minuted and show that there was some discussion around these points and careful considerations were had before decisions are being made. So really, advisors' obligation is to say, well, this is what the law says you can or can't do, or the law says this, but from a technical sense and implementation sense, it's not black and white. So in order to be able to make business judgment, we think you need to be comfortable with the following and put some criteria there about what we are expecting they get comfortable with. And that's where they would then use their business judgment to say, well, based on those criteria and the information available to me, I think this is in the best interest of the company as a whole, and proceed with that decision. Because that's really going to be the test, is what have you relied on and how much investigation did you do? One of the questions here is the turnover requirements for private businesses as a group included overseas entities or ABN based? That's a great question. Could depend on, are we talking upstream or downstream? So if the revenue is being driven through the Australian holding company, it's consolidated basis, then we might be talking about revenue here. If we're talking about an Australian subsidiary and the group is overseas, then certain revenue may not be done because the employees, the requirement about revenue, employees, and also assets are to do with the Australian business or entity. So it's something to work with your accountants and auditors on in satisfying the revenue and assets tests. That's all we do have time for today. So I hope everybody has got something out of this. As always, feel free to fill out the survey at the end. We do appreciate your feedback, and it will be the opportunity you have to register for our webinar.